everyone. Well, Richard, we've decided to do a few podcasts, haven't we? To try and update people on various issues in environmental law. This is our first one.
Yeah, there's so much going on right now. It feels like a good way of conveying what's going on as it emerges over time.
Yeah. So I'm Penny Simpson. I'm the partner at Freeths environmental law team.
Yeah, I'm Richard Broadbent, a director in the environmental law team, working on conservation matters, including nutrient neutrality, which is what we're going to be talking about today, isn't it?
It is. Because there's been this important case of Fry in the courts, the High Court. What did you think about that case, Richard?
You know, it's not entirely surprising, the outcome.
No, not surprising at all. It's a bold case to bring, right?
Yeah,
I mean, I wouldn't have thought that there was really any doubt what that judgment would be. But, you know.
Yeah. But what it's doing is it's trying to put its fingers into the gaps in the regulations because as they were arguing and as the court accepted, it doesn't say that you can apply the appropriate assessment provisions at the discharge of conditions stage. So there's a gap there. Yeah,
I mean, it was all about whether someone with outline permission that hadn't had an HRA, whether they had to then do an HRA at the reserved matter stage.
Yeah.
And the developer had been told they had to do one, hadn't they?
Yeah.
And they were saying, we don't have to do one. This is reserved matters, and we're not required to. And the court said, well, yes, you do. Exactly right. Because, and it wasn't, they were saying that not because the regulations applied.
Because they don't.
Because the regulations don't
say it on the face of it.
The 2017 regulations don't say that reserved matters have to be subject to an HRA. It says that granted planning permissions do, and that the court said that wasn't, that reserved matters was not a granted planning permission. But they then still decided, didn't they, that they had to do an HRA. And I mean, I know you were keen to explore the reasons for that.
Yeah, absolutely. Because as the court rightly said, even though those conditions had nothing to do with the impacts which would lead to the impacts on the Ramsar protected site, nevertheless, that by discharging the conditions and allowing it to go ahead, then those impacts would happen. Yeah. So it's trying to contain that. But as Sir Ross Cranston said in the judgment, there's sort of three reasons.
He was the judge, yeah.
Exactly. Yeah. And three reasons why that should be the case. So one is the direct effect of the Habitats Directive, continuing direct effect of that. Then this purposive interpretation of the directive in line with the strict precautionary principle, and then the case law, right, domestic case law on that. But and by saying, well, look, the effect of this, the purpose of the directive is to protect these sites, and I know it's a Ramsar site that's treated as if it's a European site. Yeah. The purpose of it would be affected here if this was went ahead in an unassessed form and implying the direct effect. But of course, you're on your case, Harris, on that direct effect point.
Well, I mean, this judge in Fry was obviously basically saying that despite Brexit, we needed to apply the directive, wasn't he? Yeah. And the reason why we weren't surprised to hear that from that judge is that in our case, the Harris case in September last year, we got judgment which said that. The judgment said that because of something called the EU Withdrawal Act 2018 and the provisions of that, the direct effect of European directives on our country remained, even though we left the EU. And so it was no surprise that that was one of the three reasons that the judge in this Fry case said that. But what's interesting, isn't it, is the fact that this case has come at this stage and they've lost, and it is going to the Supreme Court. Probably, I don't want to be held to this, but I would suggest that they won't win again at the Supreme Court, but they're going to open up an opportunity for a future challenge which may well succeed, and that could come after January. So do you want to pick that up?
Well, that's a really fascinating aspect of it. Yeah. And in the article we wrote, which is on the Freeths webpage about the Fry case, we touch on this point, and it's something that other people are thinking about too, as well. And that is that under the Retained EU Law Act, the provision under Section 2 of that takes away Section 4 of the Withdrawal Act, and Section 4 is what you relied on in the Harris case to have that direct effect continue in the domestic law of the Habitats Directive. So by cutting that out of the legal, legal landscape post December, what happens then? Because the thing about this Fry case is, and with many nutrient neutrality cases up and down the country, is that the problem was that we only became aware of the problem after outline planning had been given, halfway through a process, but when it comes in, you have to deal with it. And so if it's a reserve matters or here are discharge conditions, then you apply the provisions. But you take away Section 4 of the Withdrawal Act, you give the courts more leeway to depart from retained EU case law, and then suddenly what happens in those situations?
Well, that's right. Particularly when in Fry, the court confirmed that the domestic legislation does not require the reserve matters to be subject to an HRA. So I think what we're saying is that come January, when the Rule Act is in force and we have taken away the effect of Section 4 of the Withdrawal Act, come that point, there will be a greater opportunity for developers to bring the kind of argument that Fry had to the court, but this time to potentially succeed. And
and that's cases going forward, because the provision will only apply going forward. It doesn't look back.
No.
So it would be fresh cases, but look at water neutrality. That's about reductions in over obstruction of groundwater that affects protected sites. With climate change, it doesn't feel like that at the moment this summer, but with climate change, there could be more drought events, and suddenly you see that water neutrality issue replicated all over the country, and we've become aware of that at a particular point in time. Do you then allow all that development to go ahead? Where it raises an interesting question, and of course, under the Retained EU Law Act, the Secretary of State can issue regulations which preserve the direct effect.
Yes.
And you can see what that happens here.
Yeah, I mean, yes, exactly. Although the Withdrawal Act, even though the Rule Act it sweeps everything away, it's only if there is no positive decision to retain it. So it is going to be interesting. But then how about the other idea we had? Well, so we were thinking, if it's the case that all these house builders are being held up by these nutrient rules, is there a case to be made that they should rely on the derogation provisions of the Habitats Directive, or what's in the domestic regulations? It's regulation 64 and 68, I think, of the 2017 regulations. I mean, it's a bit of a wild card, but it's not something we've seen people do, but it's something that we should be thinking about, because, if there's an inability in a particular part of the country to mitigate because there aren't nutrient credits available, or they're so expensive that developments are made basically unviable by them, is there an argument that those developers should be able to derogate and say, we still need the housing and we'll do something about compensation? And if
at a strategic level,
which might mean the pressure could be taken off those individual areas. It's not straightforward, but I think with the right guidance from the government, and with the fact that we have the Rule Act that could potentially allow a slightly less restrictive interpretation, maybe that could be an option. It's something we want to explore further, isn't it?
Definitely. I mean, the whole idea of the habitats regulations, the Habitats Directive, Article 6, it's this sort of mitigation hierarchy. It's this process, right? And what is that? It's avoid impacts, make sites better, avoid the impacts, and then if you derogate, you have to analyze those derogations clearly and look at it with the best available scientific information. That's the space for the science bit. And then after that, there's space for the political decision making. That's what, of course, where the derogations come in, because notwithstanding the finding that there will be an adverse effect on integrity, you then go, okay, well then how do we derogate? And that's a political decision. Well, if we've already been in the midst of a housing crisis for years, we're now in a mortgage crisis, and that's become now a renters crisis as well.
Yeah.
At what point do you get to that? We go, well, actually, the political decision making here does tip in favour that the derogations kick in.
I know. It's going to be interesting to see, but certainly the derogations should be explored further. And I think if I were the government, I'd be looking at that.
Yeah. And so it's clear guidance on that for developers, clear guidance on that for decision makers.
Yeah.
When does it kick in? How does it kick in? And then this strategic compensation scheme.
Yeah.
And they are thinking about that. There's a policy paper talking about strategic compensation for offshore development.
There was.
Okay, well then, why not here too?
Yeah. Okay, well, that's our first podcast. I hope you all enjoyed it. We'll think of another topic and do another one soon. Thank you.
Thanks.
Bye.